Hello everyone, welcome back. This is S.C. Coleman, author. In this video, we are going to try and hopefully answer the question, who is running U.S. cybersecurity? For this particular video, we'll just run through a very short document, which appears, anyway, to be the basis for the current U.S. cybersecurity operation, if you will. I don't want to really call it a program or a mechanism. The first thing we need to start out with saying is that you could think of it as a U.S. component of global cybersecurity. That's the big deal right there. If you say who is running U.S. cybersecurity, well, that gets to the question, who is running global cybersecurity? And in that aspect, there does appear to be one simple answer, which turns out not to be so simple, but those entities running U.S. cybersecurity as well as global security are quote-unquote non-profits. I expect today the problem is much more expansive, much worse, much more spread out, and essentially most of the operations today are laundered. But if we look at the original, which appears to be this, we have a memorandum of understanding between the U.S. Department of Commerce and the Internet Corporation for Assigned Names and Numbers. Now, this document itself lacks dates exactly of when it was signed specifically. It lacks signatory dates and doesn't even have signatures on it. Some dates it does list though, but it, just like with all these documents, it could have been backdated. Anyway, let's get into it. Background. On July 1st, 1997, as part of the administration's framework for global electronic commerce, the President directed the Secretary of Commerce to privatize management of the domain name system, DNS. Okay, so first thing we need to get out of the way is that all of these things are done under whatever pretext, guise, artifice is required, without those elements actually being involved. The President, just like Congress, are simply public theater figureheads. They're there to dance, monkey dance kind of thing, right? They're marionettes, puppets, what you will. So they're just giving you the lip service of legitimacy. That's what we call it. But these people are going to do whatever they want anyway. The point here is to recognize the practical, mechanistic, operational aspects so that this stuff can be stopped. Because these people are not legitimate. They are doing everything in their capacity to do whatever they want, of course, and they all do it under this idea of something being sanctified and unquestionable. You know, the idea that if it's government doing it, you're not allowed to question it, you know, that type of thing, because the government has a quote-unquote authority, whatever the government is, of course. But they sanctify stuff in any aspect that it benefits them in their organization. And that's, of course, what they're doing here. When you read this stuff, and most logical people would say you can't just do this, but they can, because they're quote-unquote the government, right? That's what they say. They are not the government. What they do is they run what we call the government, which is essentially just a facade organization. So as it particularly pertains to U.S. cybersecurity, the understanding is the current control context is that of nonprofits. It could change overnight. It could change. All they do is just change the names. They shift it to another fictitious entity. They just make this stuff up. On June 5th, 1998, the DOC, Department of Commerce, published its statement of policy. Of course, DOC also stands for Department of Corrections and some other things. Management of Internet Names and Addresses, 63 Fed Register 31741, 1998, Statement of Policy. The Statement of Policy addresses the privatization of the technical management of the DNS and well, that part doesn't matter, but the privatization of the technical management of the DNS. So we're going to find out that there's a lot more involved with that. In the statement of policy, the DOC stated its intent to enter an agreement with a non-profit entity to establish a process to transition current U.S. government management of the DNS to such an entity. Of course, as I'm aware, at that time there wasn't a quote U.S. government management going on, but there you go again with their sanctity, where if all things have to be in control of somebody at all times, right? It can't just ever be left to the individuals, right? It's the same thing with the U.S. government constitution. The U.S. governmental constitution is designed for the people to be in control of it. Well, they can't have that. Somebody always has to be in control of something that, you know, you've got the client, the customer, and then you have the owner of the business, right? There's no possible way, according to these people's perspective, that you can have the client and customer equally own the same company for which they are the client and customer. They cannot have that above all costs, and so that's what they're doing here. They won't even recognize that perspective. So the internet community, quote unquote, cannot be left to administer the internet. These individuals, because they declare it so, must do it on behalf of every internet user. To secure these assurances, the parties will collaborate on this DNS project, and then in parentheses, for some reason, it also says DNS project. I don't know why they did that. So it says DNS project, and then brackets DNS project. It's kind of weird. In the DNS project, the parties will jointly design, develop, and test the mechanisms, methods, and procedures to carry out the following DNS management functions: establishment of policy for and direction of the allocation of IP number blocks, oversight of the operation of the authoritative root server system. That's the big one. So the first, when we look at the establishment of policy for and direction of the allocation of IP number blocks, that doesn't have anything to do with commerce, of course, because the Department of Commerce is simply just the pretext for which they're doing this, the letterhead, if you will. That single thing right there is what is the reason. That's the reason for VPNs, virtual private networks. Virtual private networks, which are not virtual private networks, are simply transitioning your IP address through different places so that you can get around this allocation of IP number blocks control structure, because that is the basis for which they can restrict access to various materials based off of a geographical location or the Internet Protocol IP. But the oversight of the operation of it for the authoritative root server system sounds to me a little bit more impactful. I don't know what an authoritative root server system, but every computer has a root which controls every function of that computer. So if you have a root server system that controls all those roots and is in fact elevated above them, that means they can literally go into any root possibly across the planet and change whatever they want. And they'd probably have done that. Coordination of the assignment of other internet technical parameters as needed to maintain universal connectivity on their internet. So this crap about the internet going down, I don't believe that's ever going to happen, at least as far as the control that these people leverage over it, because they want above all else consistent universal connectivity of the internet. Of course, they want it to be universal connectivity under their control. I expect if they did lose control over the internet, then yes, they would attempt to take it down, and they possibly do have a kill switch for that very scenario. Other activities necessary to coordinate the specified DNS management functions as agreed by the parties, because the only thing that matters is whether or not these individuals agree to this stuff. Doesn't matter whether it's legitimate, criminal, treasonous, doesn't matter to them. It's just as long as they agree to it, they can do whatever they want, because they're the ones that, quote unquote, have the clipboard. You know, in reference to the person who's operating the clipboard with the with who gets in and who doesn't type of thing. Now, here's an interesting thing that this thing is clearly written by attorneys, It's very twisty and annoying, but they have things embedded in here which tell you, and you can see happening today, about the current state of censorship across the internet. So, first, they have this whole thing about they're not going to single out any particular party or anything for disparate treatment unless it is, quote, justified by substantial and reasonable cause. First of all, those words come from the U.S. Constitution about search and seizure warrants and having reasonable cause, or that's not the specific word, I don't believe. They probable cause, right? That's the word they use. So probable cause, people hear that a lot. It's interesting that that wording is being used here in this context, substantial and reasonable cause, and will ensure sufficient appeal procedures for adversely affected members of the internet community. Well, isn't that nice? If you disagree with their decision, you can appeal it. Yeah, right, like that ever does anything. No, you have to treat these people as they are, which are enemy combatants attempting to illegitimately and criminally acquire controls over things that they don't have any rights to or claims over, other than the fact that they say they do. They don't have any legitimate founded claims based off of the multiple parameters that are required for such a thing. They just take stuff over because they can, right? Identify with ICANN the necessary software, databases, know-how, other equipment, and intellectual property necessary to design, develop, and test methods and procedures for the DNS project. This also lists coordination between ICANN and Network Solutions Incorporated. I've heard that name before. Collaborate, development of operational procedures for the root server system, including formalization of contractual relationships under which root servers throughout the world are operated. That is a big deal. Big deal. Anybody who has any involvement in technology, in computers, in coding, in networking, in absolutely just about anything, unless of course they're just one of those people that goes out and buy a computer and cell phone, and all they ever use it for is like buying stuff and browsing the internet and going to social media, they probably won't have any clue what the significance of the term root is as far as it relates to this stuff. Collaborate on the design, development, and testing of procedures by which members of the internet community adversely affected by decisions that are in conflict with the bylaws of the organization. So if you have individuals of the, quote, internet community who are adversely affected by decisions which are not in conflict with the bylaws of the organization, then it's fine. So that is exactly, that line there is a big deal. It means that the law governing the internet are the bylaws of ICANN, a nonprofit organization. Development of an accreditation procedure for registrars and procedures that subject registrars to consistent requirements. I think we know what that means. Collaborate on written technical procedures for operation of the primary root server, including procedures that permit modifications, additions, or deletions in the root zone file. I want to know where that is. Examination of the security aspects of the root name server system and review of the number, location, distribution of root name servers, considering the total system's performance, robustness, and reliability. It also lists something here called GTLDS or GTOLDS. So that would be golf in the lowercase, uppercase T, tango, uppercase L, Lima, uppercase D, delta, and then the F is for plurality, so there are many. Now, apart from all the other things that we've talked about, this section right here is equally a big deal, and it's very important to recognize what they're talking about in this section. Here they state recommendations regarding trademark /domain name policies set forth in the Statement of Policy recommendations made by the World Intellectual Property Organization. So this is what they're enforcing. And this is, I guarantee, the operational concept behind the so-called YouTube strikes and takedown requests that go to Google and all of that nonsense. And they do it under the guise of following act or whatever, the so-called act of Congress, but they're in fact doing it based off this, operationally speaking, concerning the development of a uniform approach to resolving trademark / domain name disputes involving cyber piracy. Don't you love that word? They always love to leverage that word pirate, right? Anybody who is not them and is doing something they don't like in relation to, quote, assets is a pirate, right? They love that word pirate. They really do. A process for protecting famous trademarks in the generic top-level domains. So that's going to be your like Disney garbage. The effects of adding new GTLDSs and related dispute resolution procedures on trademark and intellectual property holders. The recommendations made by other independent organizations concerning trademark domain name issues. That section right there could possibly cover this entire document. That section is the means by which they conduct the majority of censorship across the entire internet, other than, of course, the fact that they control the entire root system globally, which is astonishing. ICANN shall not act as a domain name registry or registrar or IP address registry in competition with entities affected by the plan developed under this agreement. And then, of course, there's going to be the other shoe drops where it says, unless. Nothing, however, in this agreement is intended, as I said, here's the unless, to prevent ICANN or the USG from taking responsible steps that are necessary to protect the operational stability of the internet in the event of the financial failure of a registry or registrar or other emergency. So there's your unless. They can't do it unless it's a quote unquote emergency or financial failure. Now, it states that this agreement will terminate on September 30th, 2000, but like I said, it could have been backdated. Not signed, but the signature lines are Joe Sims, counsel to ICANN, and J. Beckwith Burr, Associate Administrator, NTIA. Parties estimated 6 months cost. Now, the biggest and most interesting about this in the breakdown is under ICANN. Costs to be borne by ICANN over the 6 months of this agreement include development of accreditation guidelines for registries, review of technical specifications for shared registries, formation and operation of government root server, membership and independent review advisor committees, advice on formulation of and review of applications for recognition by supporting organizations, promulgation of conflicts of interest policies, review and adoption of at-large membership and elections process, and independent review procedures, etc. Quarterly regular board meetings and associated costs included opening forums, travel, staff support, and communications infrastructure, travel, administrative support, and infrastructure for additional open forums to be determined, internal, executive, technical, and administrative costs, legal and other professional services, and related other costs. The estimated 6 months budget, subject to change and refinement over time, is $750,000 to $1 million. Somehow that, considering what they're talking about, that seems a little low. And highly unlikely. But if this is truly the original form of it, you have to think that today the situation has to be that you have a lot, considering the number of nonprofits running around today, you know, pretending to be government in one way or another. I mean, I went into a local library recently, and the lady said it was being run by a nonprofit. I mean, that to me is just unconscionable, because as far as I had always been aware, the quote-unquote county government is the one that's supposed to be running the libraries. And since when do they just transition library ownership, quote-unquote, considering it's supposed to be owned on behalf of the people in the region, not owned by the quote government? Since when is that just theirs to personally do with as they please and give over to another nonprofit? And now it's not a public library anymore, it's a nonprofit library, right? Well, considering the vast number of nonprofits today, one can only wonder how many of them have not only access but are operating these root servers and are they're obviously working together to establish that World Intellectual Property Organization's concept of what is and what isn't owned intellectual property and by whom. And they can just unilaterally make those decisions as they please with no contention.